Supreme Court just issued 6-3 decision fundamentally rewriting immigration law, and if you're here legally on visa, green card, or citizen with immigrant family, what I'm revealing means future presidents can now deport individuals without judicial review, without appeals, without traditional due process protections existing for decades. By the end of this video, you will know all the implications. So let's get into it.
In unprecedented ruling Thursday, Supreme Court held presidential authority over immigration enforcement is plenary and unreviewable when exercising expedited removal powers. Chief Justice Roberts, writing for majority, Roberts, Thomas, Alito, Gorsuch, Kavanaugh, Barrett, held federal courts have no jurisdiction to review executive deportation decisions made under national security or public safety determinations. 3 dissenters, Sotomayor, Kagan, Jackson, warned decision creates unchecked executive power, allowing future administrations to deport legal residents, asylum seekers, even potentially naturalized citizens without court oversight. Effective immediately, any president can designate immigrant categories for expedited removal, bypass immigration courts, execute deportations within days. Subscribe, because this decision affects 45 million immigrants living legally in the United States, and understanding what changed, who's vulnerable, and what protections remain could be difference between staying and being deported without warning. Case originated from challenge to executive order designating visa categories for expedited removal without asylum hearings. Lower court struck down as violating due process. Government appealed, citing plenary power doctrine. Supreme Court granted cert and issued sweeping ruling Thursday. Majority held, when president exercises expedited removal citing national security, public safety, or foreign policy, federal courts cannot review substance. Judicial review limited only to citizenship verification. For all non-citizens, including green card holders, president's determination is final and unreviewable. Let me break down what court held, which immigrants vulnerable, what protections eliminated, what limited review remains, and implications for future administrations. Number 1, what court's ruling holds. Plenary power expanded. Presidential authority over immigration is political question, immune from judicial review when exercising expedited removal under 8 U.S.C. Paragraph 12.25. When president designates non-citizen categories for expedited removal based on national security, public safety, or foreign policy, federal courts must defer. Only exception. Courts verify person is actually U.S. citizen. INA interpretation. Majority interpreted Immigration and Nationality Act's expedited removal as granting president discretion to expand beyond arriving aliens to any non-citizens if deemed threat. Previous administrations limited to those within 14 days of entry and 100 miles of border. Court held, as Secretary of Homeland Security shall designate, grants authority to expand categories indefinitely. Due process. Non-citizens in U.S. have minimal protections when government invokes national security or public safety. When president makes national security determination, due process satisfied by notice and opportunity to claim citizenship. No hearing required, no appeal, no federal court review. Separation of powers. Immigration enforcement is executive function, not judicial. Congress delegated broad discretion through INA. Judiciary ensures executive doesn't exceed statutory authority or violate clear constitutional rights. Within statutory boundaries, president's choices unreviewable, even if arbitrary or discriminatory. Dissent. 3 justices argued ruling violates Fifth Amendment protecting persons from arbitrary action. Long-term residents, asylees, DACA recipients have liberty interests requiring hearing. Expedited removal without review creates risk of errors, gives president dictatorial power over 45 million immigrants with no check. Number 2, which immigrants, vulnerable now, green card holders, 13 million LPRs, previously entitled to removal proceedings before immigration judge with appeals. Now, if president designates LPRs from certain countries with criminal histories or meeting criteria as threats, expedited removed without hearing, includes LPRs here decades with businesses and citizen children. Visa holders, 10 million on temporary visas, H-1B work, F-1 student, tourist. Previously, if visa revoked, entitled to notice and contest. Now, if president designates visa categories for expedited removal, deported within days. No appeal, no review. Asylum seekers, 3 million pending applications, previously entitled to credible fear interviews, asylum hearings, appeals. Now, president can designate asylum seekers from certain countries for expedited removal without hearing. Claim of persecution never heard, deported to country fled. TPS holders, 700,000 from countries experiencing conflict or disasters. Now, president can terminate TPS and order expedited removal without individual hearings. Affects people here 10 to 20 years. DACA recipients, 600,000 brought as children. Previously required individual proceedings. Now, President can designate DACA recipients for expedited removal. No review of decision to end DACA and deport. Naturalized citizens risk. Dissent warned if President can deport green card holders without review. What prevents denaturalization of naturalized citizens? Majority said courts retain citizenship verification, but dissent noted becomes meaningless if executive redefines who qualifies. Number 3, what protections eliminated? Old system. Notice to appear listing charges. Bond hearing. Merits, hearing before immigration judge presenting evidence, witnesses, attorney. Judge issued written decision. Appeals to Board of Immigration Appeals. Petition for review in circuit court. Process, 1-3 years. Judicial oversight at every level. New system. President issues order designating categories. DHS identifies individuals. Notice of removal issued. No bond hearing. Mandatory detention. No merits hearing. No appeals to BIA. No judicial review. Deportation within days or weeks. No oversight except citizenship verification. Eliminated rights. Present evidence of equitable relief. Challenge government's evidence. Call witnesses. Cross-examine. Appeal legal errors. Factual errors. Abuse of discretion. Habeas corpus. Limited to citizenship only. Stay of removal pending appeals. Remaining protection. Only opportunity to claim U.S. citizenship. If claimed, DHS must verify before deporting. Burden of proof on person to prove citizenship. Difficult if detained without documents. For non-citizens, no other protections. Number 4, what limited review remains? Citizenship verification. Courts retain jurisdiction if person claims U.S. citizenship and DHS disputes. Includes native-born, naturalized citizens through parents. Curays examine birth certificates, naturalization certificates, passports. Cannot be eliminated because Constitution protects citizens from deportation. Statutory authority. Courts can review whether President exceeded INA authority. Example, expedited removal of all green card holders nationwide without any national security rationale could be ruled exceeding authority, but bar extremely high, any plausible national security rationale likely sufficient. Constitutional violations. Theoretically, courts retain jurisdiction over clear violations like removal based solely on race or religion, but majority signals extremely narrow. If President provides facially neutral rationale, national security from certain countries, courts defer even if discriminatory effect. What courts cannot review, whether person actually poses threat, whether deserves humanitarian relief, whether family separation creates hardship, whether violates international law or asylum treaties, whether determination fair, accurate, or reasonable. All unreviewable political questions. Practical effect. For vast majority subject to expedited removal, courts offer no help. Unless claiming citizenship or President wildly exceeded authority, no recourse. Order final and immediately executable. Number 5, implications for future administrations. Republican scenarios. Future Republican president could order expedited removal of undocumented in sanctuary cities without hearings, visa holders from countries deemed threats, green card holders with any crimes, TPS holders when terminating programs, DACA recipients when ending, asylum seekers from specific countries citing border security. All deportable within days without review. Democratic scenarios. Future Democratic president could theoretically use same powers, targeting immigrants, spreading misinformation, citing public safety, deporting those violating labor or environmental laws, removing those funding opposition causes, citing foreign interference. While less likely, ruling grants any president these powers. Immigration courts, erosion. With expedited removal available for all categories, future administrations may bypass immigration court system entirely. Why process through years-long proceedings when expedited achieves same in days? Immigration judges, BIA, circuit dockets could become obsolete. Chilling effect, 45 million legal immigrants now vulnerable. Green card holder here, 30 years with business and citizen children could be designated under future priorities. Creates fear, uncertainty, reluctance to assert rights. Immigrants may self-censor, avoid activism, or leave voluntarily. International implications, other countries watching. If U.S. deports long-term residents without hearings, other democracies may adopt similar. Could trigger reciprocal actions. Americans abroad, subject to similar expedited removal, undermines international human rights and asylum norms. Bottom line, Supreme Court issued 6-3 decision Thursday, holding presidential authority over immigration enforcement is plenary and unreviewable when exercising expedited removal powers. Core holding. When President designates categories of non-citizens for expedited removal citing national security or public safety, federal courts cannot review substantive decision. Judicial review limited only to citizenship verification. Vulnerable immigrants, green card holders 13 million, visa holders 10 million, Asylum seekers, 3 million pending applications. TPS holders, 700,000. DACA recipients, 600,000. All can now be deported without hearings, appeals, or judicial review. Due process eliminated. No immigration court hearing, no bond hearing, no presentation of evidence, no appeals to BIA, no federal court review. Only protection, opportunity to prove U.S. citizenship. Limited judicial review. Courts can verify citizenship, review whether President exceeded INA statutory authority, review clear constitutional violations. Cannot review substance of national security or public safety determinations. Future implications. Any president, regardless of party, can now deport categories of immigrants within days. Immigration court system potentially obsolete. 45 million legal immigrants, vulnerable to policy changes. Subscribe, because immigration law changing rapidly. And I'm tracking every Supreme Court decision affecting legal residents' rights to stay in America. 6-3 ruling just gave presidents unlimited deportation power. Understand what changed and who's vulnerable now. Next video reveals the 5 legal strategies immigration attorneys using to challenge expedited removals despite this ruling.